protected status under the NJ LAT. And so regardless of how, the liability for service in the armed forces, which is the language that's contained in LAT, is defined as subject to being ordered as an individual or a member of an organized unit into active service in the armed forces of the United States by reason of membership in the National Guard, Navy, militia, et cetera, none of which applies.
Is there any possibility in looking at his service, is he by any stretch subject to recall by the Secretary of the Navy?
He is not.
I mean, it's a complaint issue. I don't know the answer. The court doesn't know the answer, but there are categories where you can be in the National Guard, where you continue to volunteer, but there are also, as I understand it, and it's not in the complaint or in the papers, there is a sliver of individuals who are subject to recall by the government based on what their status was when they did serve. Is there any evidence that anyone is aware of in the complaint that indicates that, notwithstanding that he is no longer in active duty and not in the National Guard, is there any indication that he is subject to recall by the Secretary of the Navy?
So, Your Honor, the answer—
I didn't see it, but I want to make sure I didn't miss anything.
Yeah, I didn't see it either, and we've read the complaint very thoroughly, and it's not been alleged. I can represent to the court that, based on my strong recollection of what's in the complaint, and we certainly combed it, he hasn't alleged that. And so that's all we have to go on at this point, right?
I just want to make sure I understand the roadmap and close the exits as appropriate.
Yes. So in opposition, plaintiff, argues that he's within the protections of LAD because of his this is the hard part to try to follow, his association and advocacy for military members who are protected by the LAD. And he cites Calabata for that purpose, which really has no bearing on this case. But most importantly, associational discrimination, it's not applicable to plaintiff because plaintiff's complaint in his annual review as pled had nothing to do with his association with anyone else. So he's not saying, like Calabata, in that case where the employee who was a resident of the question really was not precisely on point as to what's happening here, but this was a plaintiff who was claiming that because his wife was suffering from cancer, that he was being discriminated against, and he had a claim for CEPA based on that, and that's obviously an associational claim, although there was issues separate and apart from, in that case, related to where the case belonged. But there's no one identified in the complaint or even in the opposition as to what occurred at that annual review where he was advocating for any person. He was
advocating for a person, or can he say that based on my experience as a veteran, I believe that McCarter and English may be discriminating against National Guardsmen, active duty, people who are subject to recall? Is there any way, liberally evaluating the complaint, that it could be read that he's saying, based on what I've experienced, I have a reasonable belief that others who may be, for example, in the National Guard, would be subject to a different set of rules?
Would be? So in other words, non-employees—
I'm saying, asking the question, would be, is that enough?
Well, I think we have to, first let me say, there's no allegation in the complaint that he complained about anyone other than himself based on his veteran status. And that was the genesis of his complaint to McCarter at the annual review, giving him the benefit of the allegations pled by him. But he has certainly not identified anyone else. Right? There's nothing in the complaint where he's identified any individual in a protected class, either generally, as Your Honor has posited, or specifically in the complaint that he's ever pointed to someone and said, I'm now advocating for this person who's employed by McCarter and English, and that's the association, the discrimination that I'm claiming under LAD for which I was terminated. So
would there ever be a circumstance that says, and just that because you are treating me as a veteran, and this is a question of law, that you're treating me as a veteran X way. Let's say as a veteran, assuming that there is no prohibited classification under the LAD, because you're treating me this way, I'm drawing the reasonable inference that you would treat others similarly situated, such as National Guard members, similarly, which would be a violation of the LAD. You can follow the daisy chain. It's fine, because the liberal application, the liberal review of the complaint, just want to make sure there's nothing that you're identifying that says it could be that because you treated me X, then I can reasonably infer that others, such as National Guardsmen, etc., who are subject to you, Sarah, would be discriminated against.
So so first is, in the cases under SEPA that relate to NJ LAD, right, you have a couple of, first, associational discrimination claims have been recognized when an employer discriminates against an employee because of his association with a protected class. That's O-Lone versus New Jersey Department of Corrections, 313 NJ Super at 254. So there you would have identified a specific member of the protected class. Here that was not done. Second, such claims are cognizable when employees are retaliated against for supporting a coworker who asserted a viable discrimination claim. So there has to be the discrimination claim that the coworker asserted, and then as an associational discrimination claim is potentially cognizable if that employee, who was not subject him or herself to that claim, supported someone who was advancing that claim. And that is at Craig versus Suburban Cablevision 140 NJ 623.